Hello and welcome to our webinar, Unlocking the Draft Digital Personal Data Protection Rules 2025, What It Means for Businesses. On behalf of Khaitan and Company, I would like to extend a very warm welcome to each one of you and of course, Happy New Year. I'm Shupratim Chakraborty. I'm a partner in Khaitan and Company, specializing in data and technology laws. I've been fortunate to have assisted some of the prominent domestic and international clients in this space and also the government in overhauling some of the digital laws of the country. And today I am the moderator and co-speaker along with my fellow partners, Smita Jha, Abhinav Chandan, and Anisha Chand, whom I'll be introducing very shortly. Let's talk about certain housekeeping rules and the agenda. The Digital Personal Data Protection Act marks, of course, a pivotal moment as India's first comprehensive national legislation on data protection. This transformative law is set to significantly reshape how businesses manage personal data. After considerable anticipation, the Ministry of Electronics and Information Technology has finally unveiled the draft rules under the DPDP Act, which is now open for public consultation until the 18th of February 2025. This webinar aims to delve into the critical aspects of these draft rules, the challenges they present for businesses, the practical approaches to achieving compliance effectively, and most importantly, right now, the possible recommendations that the industry may put forth to the ministry as part of the consultation process. The presentation would be followed by a question and answer session. We have already received several audience questions, and if you have any other question as we go along, please do submit them using the facility that has been provided in this webinar portal. If we cannot cover all questions during the webinar, be rest assured that we will be responding to you separately through email after the webinar. Also, please note that after the webinar, you will be receiving a copy of the presentation and a link to the recording of this webinar. Some of these requests have already started coming in. The presenters here, I would like to introduce who are my co-partners and speakers. Firstly, Smita Jha. Smita is a partner in the banking and finance, fintech, and privacy and data protection practice groups of Khaitan and Company. Her expertise lies in advising banks, financial institutions, startups, fintechs on debt funding, product structuring, data privacy, and regulatory advisory aspects, amongst other things. Next is Abhinav Chandan. Abhinav is a partner in the TMT, privacy and data protection practice groups of Khaitan and Company. He specializes in telecom, technology, and data protection laws and also regulations, and focuses on emerging areas such as AI and M2M communications. Abhinav is also an expert on corporate commercial transactions in the telecom and technology sectors. Last but not the least, Anisha Chand. Anisha is a partner in the competition, antitrust, privacy, and data protection practice groups of Khaitan and Company. She is certified CIPPE professional. She advises clients with a digital tech interface on a variety of issues in both the practice areas that she covers. Anish has been consistently recognized for her expertise in Chambers and Partners, Who's Who Legal, Legal 500, etc. So with that, without further ado, let me get started with the presentation today. Once again, it is an absolute pleasure to address you all today as we delve into the significant milestone in India's privacy and data protection journey, the draft digital personal data protection rules under the Digital Personal Data Protection Act of 2023. For businesses, these draft rules present both opportunities and challenges actually. On one hand, they offer a framework to build trust with consumers, employees, by adopting robust data protection practices. On the other hand, they introduce compliance requirements that will demand careful planning, resource allocation, and possibly significant changes to existing practices. As you can see on the slide right now, this has been the journey. As you were speaking, it has been long journey from the DPDP Act formulation, right from July, August 2017 till now. The prominent question that is coming forth right now, what next? Okay. Um, so we are aware that on the 3rd of January, the draft DPDP rules have been released for consultation, and we can go to the next slide. So probably what will happen next is up to 18th of February, the consultation inputs will be taken in, and I would request all of you to put in your suggestions, recommendations to the ministry. It has been told that this will be kept confidential and not attributed specifically publicly to to any particular organization or person. After this, possibly about a month or month and a half could be taken to assimilate everything going right, could be required to assimilate all inputs. And if things go as per speed, that speed, I think we should see that this draft rules then get rolled out. And once that happens, the first thing that will occur is that the Data Protection Board of India will get established, and the provisions pertaining to that will come into effect immediately at that time. And thereafter, the remaining provisions will be coming into effect at a later date. Possibly this could be about 2 years time that could be given. That's what we hear right now, but again, nothing has been formally communicated yet. This is something that the minister called out in one of the interviews. But word of caution here, from international experience, we have seen that even a 2 year time period is not sufficient for organizations to ramp up their capabilities as far as such a massive law in the context of data privacy protection are concerned. So I think this is a good time that we should get started with the preparation of the DPDP Act, including the rules. With this, I will hand over the mic to Smita to take you through the next part of the presentation. Over to you, Smita.
Thank you, Shupratim, for that context setting and giving us the right kind of background in terms of the timelines, etc., which are expected. I will quickly take the audience through two important concepts that have been introduced or elaborated in the rules. One is the privacy notice that has come in. It's also one of the most anticipated parts of the DPDPA rules that were expected, and frankly, one of the reasons why the implementation was kind of kept on hold, or for that matter, the industry gearing up for the implementation of DPDPA was actually looking to for this particular guidance to really come in. Privacy notice, as we all know, is a requirement that needs to be provided either prior to taking the consent from the customer or along with the consent that is being obtained from the customers. There are two or three key aspects of privacy notice that everyone should keep in mind. The first is, first and foremost, is the rationale as to why a privacy notice is supposed to be provided. It's basically to ensure that a data principal is getting a fair account of details that will be used, that why their data will be used and what is the purpose of it, which will enable them to make an informed decision about whether they really wish to provide their personal data or not, and how exactly it is going to be utilized. The next component of it is basically the form and manner in which privacy notice needs to be provided. There are four very important elements of privacy notice. One, the itemized set of data which is required to be provided by data fiduciaries to the data principal. This basically means what are the key components of data that a customer or a data principal needs to provide to its service provider, who will be the data fiduciary in this case. The second aspect is the specified purpose for which the data is required to be provided. The third aspect is again going to be the itemized description of the goods and services that the service provider or the data fiduciary in this case is going to provide by processing the personal data of data principals. And the fourth aspect, which is also a very, very important aspect of privacy notice, is basically providing or detailing the mechanism for the data principal for them to be able to make a complaint or escalate any issues that they are facing with respect to data fiduciaries obligations not being met under the act, or any breaches that data principal is facing by the data fiduciary, and make that complaint or escalate it to the board which is proposed to be set up. To give an example of why a privacy notice as has been a gating reason in terms of all the implementation efforts that are being proposed or implemented by the industry, was essentially the fact, the huge difference between how a consent architecture or a privacy policy is perceived pre DPDPA, and the kind of detailing which is required to be done in a privacy notice post DPDPA. And given the requirements of specificity or in the notice, most of the industry was really looking forward to implement it in the manner which is prescribed in the rules. To give you an example, as a data principal, if I am looking to access services of an e-commerce marketplace, for me to get onboarded onto the marketplace website or their application, there are some fundamental details that I'm required to provide, which includes my name, potentially email address, my phone number, and my physical living address as well, where the goods or services are proposed to be delivered. Now, if we look at the privacy notice requirement, the way this needs to technically work out in under the DPDPA is basically the itemized requirement, which is a name, phone number, address, email address, is something that is required to be itemized by the e-commerce website in the notice that comes to me, that these are the details that we are accepting. The next line of important information needs to be what exactly is the e-commerce platform going to do with that data, which is basically processing that personal data to facilitate providing those services or ensuring delivery of goods and services. The third aspect is itemized description of the goods and services, right? So that will basically mean all of the services that the platform is expected to provide. Maybe taking an example of an Amazon as a marketplace. I think some of the services that they provide is basically their ability to let me access the marketplace, have the goods delivered, potentially also provide some of the financing options that they market or advertise over their platforms. So those become some of the goods and services that the marketplace proposes to deliver. That is also something that needs to be itemized. And lastly, now the privacy notice also needs to provide me a link which explaining or setting out the mechanism by which, if I have a data breach kind of an issue, I basically get it rectified and escalate my concerns to the board. So that's on the manner and construct of the privacy notice. The next aspect is, who does this requirement really apply to? It definitely applies to prospective customers for all of data fiduciaries. But even for existing customers or legacy customers, the requirement is that once the rules come into effect, the privacy notice is also provided to the customers. The last aspect that I would like to harp on is basically the requirement or the privacy notice providing enough avenues, recognizing the data principals' right to withdraw their consent, and providing enough adequate support or links and communication through which consent can be withdrawn. Second aspect of that is going to be around their ability to exercise their rights under the DPDPA. And lastly, the form and manner of privacy needs to be independent and understandable. What that means is that it cannot be clubbed with the terms and conditions for accessing an application, or it can't be hidden in a overall privacy policy that is provided. So that's the basics around how to go about drafting your privacy notice, and the timelines for implementation, and when do you, like, who exactly needs to be the recipient. It is your existing customer as well as the prospective customers. So I'll quickly move on to the requirement of consent managers. Now, Consent manager as a concept is quite akin to the concept of account aggregators in the financial world. It is basically supposed to be an interoperable platform where uh, interoperable platform for facilitating data principles to provide consent in an efficient manner, and for data fiduciaries to have that consent processed for the to enable them to provide their goods and services to data principals. Like I mentioned, the consent manager as a concept is quite akin to account aggregator framework with really some amount of key differences. What the rules have basically done is set out a bunch of requirements for consent managers, which range from eligibility requirement for getting that registration from the board. Sorry, before I really move on to discussing other aspects of consent manager, please do keep in mind that consent manager as an activity is basically a regulated activity, and it requires a pre-authorization from the board, which is proposed to be set up under the DPDPA. The rules set out, the much awaited eligibility criteria for consent managers, which are quite apparent in terms of, or for that matter, quite expected in terms of what the government was looking at when they were framing this requirement. One is around, adequate disclosures around ownership, um, certain net worth requirement, and them having a financial wherewithal to be able to own and operate this business. There are three things which are important here in terms of consent manager. uh, uh, the key aspects are basically going to be, one is the proposed business models which one can look at while discussing consent managers. The second is going to be key differentiators from account aggregator framework, and third is some of the key considerations which have been set out. So as you can see on your screens, the deck, I think we have already elaborated on what the basic requirements are, and the rules are pretty clear. There are three things that I would harp on in terms of requirement. One, consent manager has to be data blind. What that means is that they don't really have the ability to store data or run analytics on that. The second aspect is around no subcontracting or assignment of obligations by consent manager without the approval of the board. And the third aspect is around avoiding any kind of conflict of interest with the data fiduciaries, right? So the reason why I'm harping on these 3 points is because this is very, very crucial for understanding a set of business models that can be adopted by consent manager. In terms of business modeling of consent manager, typically, when you think of a setup like this, you will always imagine it in a manner whoever is the beneficiary of the system should ideally be paying for it. If we look at this entire system in which consent manager operates, the key obligation to understand and implement a consent architecture is basically on data fiduciary, right? What this framework does is eases that burden and provides an avenue to a data fiduciary to ensure that instead of they themselves having an independent consent management system within themselves, they can basically look at relying on an independent consent management system which has been set up by a consent manager. So naturally, we would think that the biggest beneficiary over here is actually going to be a data fiduciary, and that's why they are the ones who should be paying the fee. But if you relate it with the conflict of interest point that we already talked about, it's going to be extremely hard for a data fiduciary or ability of consent manager to basically charge the beneficiaries at fiduciary, because that impacts the privacy concerns of data principals in a very, very difficult manner. So while the obligation is on the manager to protect the data which is provided by data principals, If they charge for it from the fiduciaries, then there's an obvious conflict of interest. So the next segment automatically becomes data principles because it gives them an avenue for efficient management of their consent, and it reduces the consent fatigue for data principles. But the question on that really is, you and I as a part of this ecosystem, how willing are we going to be to make a payment to a consent manager for protecting our privacy? And those discourses really become very important in terms of what kind of model that can be implemented. I would, one of the last things that I would really like to talk about consent manager and an account aggregator framework is basically potential resemblances and differentiators, right? So when we talk about resemblance, I think both are supposed to be platforms for managing consent from data principles. But the key differentiator between the two concepts is account aggregator already has a regulatory push from the RBI, and the whole concept has actually been bought in by SEBI and IRDA as well. And the RBI has actually mandated financial institutions that wherever their customers consent to them providing information to the account aggregator, and that being fetched by a financial institution, in this case a user, they are technically mandated to provide that information, right? However, in case of a consent manager, because it cuts across various sectors and all, we don't, at least the rules do not provide for that regulatory push mandating the data fiduciaries to actually provide or integrate with the consent managers and provide them that information to the extent the data principals actually agree to such inter transfer of their information between data fiduciaries. So in absence of a regulatory push, it becomes even more difficult for a consent manager to actually effectively perform this duty. And the second aspect is, while account aggregator framework is also expected to be data blind like a consent manager, we have seen various models emerging in the market where there are potential tie-ups with technical service providers, etc., who do end up running analytics on the financial information which is fetched by account aggregators and doing that value add, potentially another stream of revenue for account aggregators. At this stage, from a consent manager perspective, there is no such differentiation which has been brought in. In fact, any kind of subcontracting is entirely with the approval of the board. So it will really be interesting to see how exactly this ecosystem really evolves. And the last thought around consent manager and business models, we just spoke about one model which is going to be entirely fee based. And the question really is going to be who becomes that fee payer. While that gets debated, there are two, three other models which are possible. One is a completely non for profit, government backed consent manager who does this, who undertakes this exercise completely for non-profit, and just be seen as a protector of data principles rights, etc. That's one model. Second thing, where the rules are sort of silent while they do talk about conflict of interest, is these large BFSI groups creating their own in-house consent management entities, subject to, of course, the conflict of interest related requirements, and there having been enough discussions with the board, and regular arm's length principles being applied. And the last one could be some sort of a value add that could be done in respect of consent, in respect of the services which are proposed to be provided by the consent manager. I think I'll just take a pause there. I believe I'm already overshooting time. Shupratim, over to you really on this. And
No, I think, Smita, I don't think that this at all matters that you've overshot a little bit, because you covered, I think, couple of very important critical pillars of this particular rules, beautifully explaining the notice aspect and also this consent manager demystification that you have done. I don't think anyone could have done it better. And we have got tons of questions already coming in. I would like to just pick up two, Smita, if you're okay. One is from Zin, and Zin is asking, does the privacy notice need to be in all Indian national languages?
That is correct. The whole point of privacy notice is basically you cater to a customer in the language that they understand. So the requirement right now is that you provide it in all Indian languages. The way I would really go about it is that if you're catering to customers in a particular geographical area, just be very cognizant of some of the prevailing languages in that area. But yes, absolutely, it needs to be in all languages. I think that comes
Excellent.
from the
And
main legislation
yes,
itself.
that comes from the DPDPA, correct. And the next question is, from Apurva, and she's asking that can a consent manager serve two data fiduciaries who may or may not be competitors?
Absolutely. The whole idea of a consent manager is to be completely independent and have no conflict of interest. In fact, the way I would look at it, the idea should be that any data fiduciary who wishes to come and avail services of consent manager should be given that opportunity and avenue. Of course, one of the business models that I talked about, where it's for a group, a BFSI conglomerate, over there the considerations may be different, and frankly, the rules are silent on that. But I think impartiality and no conflict of interest is the basic requirement for a consent manager.
Thank you. Thank you so much, Smita. And now I'll move into my part and we can move to the next slide. I'll take a couple of concepts from the rules and talk about it again, most important from a from business perspective. The first one is reasonable security safeguards. There are certain baseline requirements which have been called out. The demand from the industry also was that if certain security standards could be called out, like say ISO, as you see in the Information Technology Act, and the reasonable security practices, procedures, rules for sensitive personal data. It's already called out there. The good and bad part is there is no specific standard which has been called out under this set of rules, but they have given certain thumb rules, and you can see these in the deck in front of you, the slide. I'll quickly take you through the pointers. As you can see, one needs to include appropriate provisions and security safeguards in the contract with data processors, which makes it extremely critical once again that we would say that whether it is a data fiduciary, data processor and a processor, or whichever combination, permutation and combination, please ensure that you have appropriate contractual insulations and provisions in place. Definitely, this is mandatory to have a contract in case there is a data fiduciary and a data processor relationship. Next is application of robust technical and organizational security measures, uh, encryption, obfuscation, masking of personal data, use of virtual tokens, implementation of appropriate access control mechanisms to computer resources, maintenance of logs for visibility, monitoring, review of data access, ensuring continuity with backups in case of data compromise. And the last one, very important, is retaining of logs and data for 1 year for detection of an investigation. So, in case there is an incident, this seems to hint that you'll have to keep those logs for about a year unless another law talks about it differently. Interestingly, the cert in direction that came in, it talked about maintenance of all ICT system logs for a rolling basis of 180 days within India. That is already in play. Now, with these rules coming in this form, this could mean that you'll have to now keep that log for about a year in case it has been part of some incident. Okay, so important one to take note of for businesses, tech teams. We can move on to the next slide. The other important thing that I would like to cover is intimation of personal data breach under the DPDP Act, including the rules. So, very in a nutshell, it's like a three-pronged approach that has been talked about. In case there is a data breach which occurs which involves personal data, then you'll have to go to the Data Protection Board of India immediately and give certain information, which is I would say again, simple set of information. The details are provided on the slide. Within 72 hours or such longer period as the Data Protection Board tells you, you'll have to go and give further information. If you see on the right hand side, the details have been provided as to what all you will have to provide at that juncture. Trust me, in 72 hours, organizations could really face an uphill task to provide so much information. Therefore, there is a possibility that this could go down the same route like we are observing in relation to reporting to cert in. Okay, what is happening is players who intend to report or need to report, they are providing whatever information is available at that juncture, which is a 6 hour breach reporting requirement right now under certain direction. They're providing as much as possible, say within the 6 hour, or even if they have breached the timeline soon thereafter, they are kind of giving explanation and providing that input and requesting for more time to come back with further information. Probably on a practical basis, this is what will happen in relation to reporting to the data protection board as well. You go immediately, do the basic reporting, go back again with further information, whatever is available, and maybe in the first reporting or in the subsequent reporting, you ask for some more time to give this full details, right? The other thing that you'll have to do in relation to breach reporting is inform the affected individuals. And if you see, there's quite a bit to be told to the individuals as well. Interestingly, if you look at the 72-hour breach reporting requirement to the data protection board, the last line item is talking about the reporting that you have done to individuals. So de facto, it kind of assumes that you have already done the reporting to individuals within that 72 hours, right? Which could be again very difficult. So maybe some more time would be required to be sought from the board to do such reporting, depending on what situation has occurred, of course. So for businesses, I think that in a nutshell, within 6 hours, you'll have to go to the certain, because in most of the cases, it will be a cyber incident which requires mandatory reporting to certain. And if it involves any personal data breach, you'll also have to go to the Data Protection Board of India. So you go to certain, you also go to the Data Protection Board and report. Within 72 hours, again, you go to the Data Protection Board and give further details unless a larger time is allowed by the board. And also you need to go to the individuals and do a reporting. So very important one for businesses to take note of. With that, I come to the end of my portion of this presentation, and I now would request Abhinav to take over and take through the remaining part.
Thank you, Supratim. So another aspect that may be crucial from the perspective of business operations and logistics is the obligation imposed upon the data fiduciaries to obtain verifiable consent. The Act originally spoke about verifiable consent for children and persons with disabilities. And immediately at that time, this had gained a lot of traction, especially for social media companies, content service providers, and educational and health institutions, which generally deal with data of such users at a large scale. Questions had then immediately arose on the manner in which this verifiable consent would have to be obtained, and what might be the cost, operational, or organizational and logistical implications that would entail. Now, the rules finally elaborate on this requirement, and from a business perspective, the rules require that the data fiduciaries must implement necessary technical and organizational measures to ensure verifiable consent, and it has to be obtained from the parent in case of a child, and from the lawful guardian in case of a person with disability. Now, for processing of data relating to children, the rules mention that the data fiduciary must obtain verifiable parental consent and observe due diligence for checking that the person identifying as the parent is an adult, and that person is also identifiable, relying on reliable details of age and identity that might be already available with the data fiduciary, or it may be through any voluntarily provided details of identity and age, or maybe through a virtual token which is mapped to the same, that is issued by the government or under law, and can include DigiLocker details as well. Now, as I said, interestingly, the language prima facie suggests that the data fiduciary must ensure that the person identifying as the parent is an adult, indicatively meaning that the parentage does not need to be verified by the data fiduciary as long as the person is an adult. However, a more complete interpretation might be that the person identifying as a parent should actually be the parent, considering that an obligation is imposed by the Act itself upon data principals as a duty that they should not impersonate another person, and even a penalty is prescribed. So it can be argued that the obligation here indirectly would be on the data principal to not impersonate or provide inaccurate details. As far as the data fiduciary is concerned, it may be contended that their obligation might be seemingly restricted to only verifying that the person who is identifying as the parent is an adult. This is important as because an alternate interpretation would mean that the data fiduciaries would need to verify parentage as well, and in each case, which may not be the intent of the legislation. Now, for persons with disabilities, the rules say that the verifiable consent must be taken from the lawful guardian, and it would apply in cases of the user suffering from mental or physical impairment, uh, which results in the user being unable to make legally binding decisions, or basically not being able to validly enter into contracts. The other cases include mental retardation, autism, and cerebral palsy, or a combination of these factors, or maybe several severe multiple disabilities, where it is assumed that there is no capacity to make binding decisions or enter into contracts. So, in these scenarios, the data fiduciaries must observe due diligence to verify that such guardian is validly appointed under the laws applicable to guardianship. So, the rules also identify these laws. There are two specific laws essentially which cover various types of disabilities and the manner in which the guardians are to be appointed and their guardianship powers. But this does seem to be a higher standard of due diligence comparatively compared to children, since the validity of the guardian's appointment needs to be verified in this case. We can move to the next slide. So now, while the rules prescribe the requirements relating to verifiable consent, it also goes on to provide certain exemptions where verifiable consent in relation to data of children or persons with disabilities would not be required. This exemption also applies to the requirement under the Act, which restricts data fiduciaries from undertaking any targeted advertising or behavioral monitoring or tracking in relation to children. Now, for verifiable consent, the rules specify the exemption in two categories. First is applicable upon data fiduciaries in general, that is, if they are clinical establishments or allied healthcare professionals or educational institutions or childcare entities, but only if they meet the corresponding prescribed conditions which have been prescribed in the rules. For example, in case of clinical establishments, the exemptions would apply only towards processing that is restricted to provision of health services to the child. Now, the second category of the exemption is based on purpose, which includes things like performance of state functions or providing benefits, etc. But again, the processing should be restricted to the extent necessary for undertaking such activities. Under a separate provision, the rules also prescribe an exemption for research, archiving, and statistical purposes. Again, certain minimum standards are specified, such as data minimization and regarding the period of retention for availing this exemption. We can move to the next slide. Calling for information. So, we have spoken about verifiable consent requirements and certain exemptions, which is relevant for businesses. But another aspect which might be noteworthy is the government's right to call for information from any data fiduciary or an intermediary. Uh, if we can recall, Section 36 of the Act empowered the government to seek information from data fiduciaries and intermediaries. And these rules now seek to establish certain procedural embellishments and safeguards around that power. These guardrails are again twofold broadly. First is on the grounds on which such access to information may be sought by the government. This includes matters relating to sovereignty, integrity, or security of India, or for performing state functions under law, or disclosure of any information for fulfilling any obligation under law, or for determining and then notifying that a data fiduciary or a particular class of data fiduciaries are to be considered as significant data fiduciaries. Second guardrail is that only authorized persons corresponding to these grounds that we just discussed can call for such information. The details of who the authorized person will be is provided in the rules. Now, these guardrails would be of or maybe of particular interest to data controllers in the EU who are seeking to transfer information into India for processing. Considering that under GDPR and EU law, the controllers are required to assess whether the laws of the recipient country, which will be India in this case, uh, whether these laws provide sufficient safeguards against government access to personal information. And this had taken more significance after the Schrems II ruling in the EU back in 2020. So this rule can thus be a point of consideration for companies undertaking transfer impact assessments under EU law. That's it from my side. Over to you, Supratim.
Thank you, Abhinav. I think you picked up some of again very critical aspects of this particular set of rules, and tons of questions have started coming in. I will pick
Yeah.
up I think one question which has come from Pratibha, and Pratibha's
Yeah.
question is, what role does the Data Protection Board play in resolving disputes related to verifiable consent? Any examples on this?
So this needs to be seen, and maybe a consultation point on which we can seek more guidance.
Right. Thank you, Abhinav, and I think we'll move on to Anisha. Um, I think so. So, Anisha, over to you.
Thank you, Supratim. Thank you, Abhinav and Smita as well. I will be discussing three areas in the draft rules. The first is on the rights of data principals and how they need to be effectuated as per the rules. The second is the additional obligations for significant data fiduciaries. And third, and the most important, I would say, is relating to cross-border transfer of data that has created some controversy already. But starting with the less contentious aspect, which is the rights of data principals. What the law and what the mother legislation, the DPDP Act already tells us is what these rights are. So data principals, very quickly, we'll recap what these rights are. So the first right is the right to seek summary of all information that is being processed, to get identities of all processors and fiduciaries with whom this data has been shared, a right to grievance redressal, right to correction and erasure. These are broadly the rights. If you could just go to the next slide, please. Right. So what do the rules tell us? Now, rules explain the modalities on how these rights need to be exercised, what measures and means do data fiduciaries and equally in some cases consent managers need to adopt to be able to, like I said, effectuate these rights of access to data principals. So both data fiduciaries and consent managers, for example, are required to publish on their websites or their respective apps the details on how data principals can make their request to exercise their rights. All necessary sort of identifiers, it could be usernames, customer ID, application references number, which are required to identify them, also have to be provided as per the terms of the services that the data fiduciary has engaged the data principal on. Similarly, for grievance redressal matters, which is an important pillar under the scheme of the Act, data fiduciaries and consent managers are required to disclose the response time within which they will get back. Interestingly, no time period has been prescribed, so it is sort of left to the discretion of the data fiduciaries, which I think is very pragmatic. Everybody should be able to decide, but at the same time, their timeline should not obviously be indefinite. There has to be a reasonable period within which they should be able to resolve and get back on the request that the data principals have made. Equally, rules also clarify that data principals can nominate individuals, and those individuals should also be able to exercise their rights using the same means and the identifiers, particularly when there is an event of death or incapacity. Now, what this means on balance for corporates is that you need to start thinking about what means you or what modalities you're going to have, what mechanisms you want to put in place to enable data principals to access these rights. These are important rights forming the backbone of the Data Protection Act and the law framework of India, and whether you need to give them access through portals, put in contact details, dashboards, all of these things have to be now thought through. Similarly, one of the important rights that data principals have, particularly where consent is the basis for processing, is the right to seek erasure of their personal data, and the data fiduciaries are obligated. If you can just go to the next slide, maybe. Obligated to erase all the personal data upon occurrence of two events. One is where there is withdrawal of consent by the data principal, and the second is where the specific purpose for which the data was collected is no longer being served. The exception to these rules is where retention is required for compliance with any applicable law. Now, the Act also explains very lucidly when the purpose is seen to be fulfilled or where the purpose is no longer being served. It is in those cases where the data principal has not approached the fiduciary for performance of any specified purposes, or where it has not contacted the data fiduciary for exercise of any rights. And the Act also indicated that there will be specific time periods that will be indicated. Now, once again, coming back to what the rules tell us, the rules provide us what are the classes of data fiduciaries and what are the timelines which are prescribed for legitimate retention periods. The classes of data fiduciaries that have been called out under the rules are three: e-commerce entities, social media intermediaries, and online gaming intermediaries. Each of these expressions have also been thankfully defined, and the period which has been given is 3 years for all of these entities. But upon closer look, what we find is that the 3-year window, 3-year maximum retention period, is applicable for large e-commerce and social media entities which have a minimum user base of 20 million or more. And similar 3-year period is also applicable to online gaming intermediaries which have a lower threshold in terms of user numbers. It is 500,000 or 50 lakhs of users or more in India. So these are the thresholds. Now, the time period that is going to be considered for computing whether I'm breaching this 20 million or 500,000 threshold is not something that's clarified. So there could be situations in real life where some of these e-commerce entities may be breaching these numbers for a few months, but all of those things, I think, when rubber hits the road is the time where these will be tested. The rules also prescribe that you have to contact and give notice of at least 48 hours to the data principals prior to erasing or deleting the personal data. And the schedules which sort of support and give more clarity on these aspects very clearly state that all the data has to be erased for all purposes except for enabling the data principals to access the user account. So after 3 years, somebody wants to access that minimum amount of information could perhaps be saved, or enabling access through any virtual tokens that is issued by the data fiduciaries for provision of goods and services on its platform. So like I said, if you are a social media intermediary or an e-commerce entity or a gaming entity, then you just need to be mindful of what these periods are. And of course, this is a draft regulation, so you feel free to give in your comments if you think the window should be larger or if some tweaking is required. But speaking of large-scale e-commerce entities, I think this makes for a good segue into the next slide. If you can just maybe move to the next slide. We're going to talk about the significant data fiduciaries. We've seen some questions have come pouring in. So I'm going to start with what significant data fiduciaries are. So again, the sort of explanation lies by default in how they are framed. They are supposed to be data fiduciaries which are dealing with large swathes of information, large volume of information which could be sensitive, which could affect the rights of data principals. They have an impact on sovereignty, integrity, election outcomes, etc. So these are the directional factors based on which the government can, by notification, which will be separate from the rules, will form the basis of coming up with the class of data fiduciaries who may be classified as significant data fiduciaries. So the rules were not supposed to call out these significant data fiduciaries, and therefore they haven't. there is going to be a separate notification. So what we know right now is not the classes of data fiduciaries, but we continue to know what we've already known for a year and a half approximately, that these are the factors that will go into determination of data fiduciaries. I think this answers one of the questions that one of the audience has raised. But again, just staying on the Act for a while, because that also listed out what obligations significant data fiduciaries have to follow. If you can just go to the next slide. So the first obligation is to have periodic data protection impact assessments and audits. What we now additionally know from the rules is the frequency with which these audits and impact assessments have to be undertaken. So the rules tell us that they have to be undertaken every 12 months, or sort of annual audit has to be taken. And interestingly, the findings are not for the data fiduciary alone. The findings have to be mandatorily shared with the Data Protection Board of India. The other obligation, which was again envisaged in the Act, and there's no further light that has been shed under the rules, is appointment of the data protection officer based in India, who will be the focal point of contact for grievance redressal, etc. The two incremental obligations that have found its way into the rules is one, that SDFs or significant data fiduciaries have to observe some level of due diligence to verify that the algorithms that they're using, the algorithm software that they're using to process personal data, including for hosting, publishing, storage, etc., will not pose a risk to the rights of the data principals. And this insertion comes at a very opportune time and sort of has trappings of areas that are covered in this recently released report by the MeitY on AI governance and guidelines development, which has been framed to analyze gaps and offer recommendations for developing a framework for AI governance in a bid to encourage responsible AI and bring in more accountability. But once again, there is no guidance or bright line test for what this due diligence level should be. So it's likely to be a case by case analysis, possibly on a best effort basis. Another top of obligation, which again is fairly popular and much talked about already, is sort of, if you can maybe go to the next slide, or you can stay here. Sorry, you can stay here. The top-up obligation is that SDFs may specifically, this is a specific obligation for significant data fiduciaries, again, may be subjected to some sort of a data localization requirement or some restrictions on transferability of data for certain classes of personal data and traffic data. Now, these requirements are going to be determined by the central government through a committee, which is expected to specify what these classes of personal data would be. And very recently, the secretary at MeitY has made some remarks to explain what this traffic data would be. So he said that this could likely be flow pattern metadata, and also that data localization provision for SDFs is going to be very, very limited in scope for very limited purposes. But regardless, there is no formal clarification on this, and until then, this has, like I said, spurred a bit of controversy on two counts. One is because this could mean that there could be some sort of segregation of data that will be required by significant data fiduciaries, because we did away with the concept of critical personal sensitive or non-sensitive personal data, but now there will be some sort of segmentation that may be required, which means that your cost of compliance could get amplified. And the second is a more obvious one, which is this a departure from what the scheme of the Act is? Because the Act, again, just to recap, and now perhaps, just to recap, the Act allows free transferability of data except to those blacklisted jurisdictions that the government has the power to notify, or in cases where data needs to be localized, it will sort of depend on the sectoral regulation, where there's a higher degree of protection that has been mandated by a specific law, then that needs to be followed. So these were the only two exceptions to the rule, but now this is sort of creating another carve out where data may require different treatment and could be subjected to some sort of localization or transfer restrictions. So there is certainly, this has created some sort of stir in the market. But again, this is just a draft. This is going to be, the government is going to receive feedback, and let's see how it finally shapes up. But this brings me to the final provision on cross-border data transfer that is contained in Rule 14 of the draft rules, where the central government has retained the power to notify certain restrictions or conditions for sharing or transferring of personal data with foreign states or their agencies. Um, this again is something that Abhinav has already alluded to, where data fiduciaries could face challenges, and especially data fiduciaries who are processing, who are offering goods and services in India and processing data principles based in India. So if they are outside India, they can certainly face challenges in sort of navigating and reconciling this new restriction with obligations that they need to fulfill under foreign laws that allows or the disclosure, or that requires disclosure of personal data with government agencies. So this is again a new one, and again, let's understand why this provision has somewhat rocked the boat. It's because, again, free transferability of data except to blacklisted countries, and localization where specific legislation requires. These were the only two exceptions. Now this seems to be a slightly newer requirement. But if anybody has heard, the minister recently, he seems to suggest that there is no departure, there is no conflict, and it's only to create more flexibility, and they're going to be mindful of what the sectoral laws have to say, and what is the right thing for India to do, being mindful that the business is not disrupted. Uh, but again, it brings me back to the point that this is why stakeholders must necessarily participate in this public consultation, provide some constructive feedback, and iron out any sort of discrepancies, whether prima facie or when seen with a focused lens. So with that, I'm going to give the baton back to Supratim.
Thank you, Anisha. Splendidly explained. And before we move on to the audience question and answer, one specific question that has come in the context of what you covered, and I'll read this out. How will the additional significant data fiduciary obligation of restricting transfer of personal data and traffic data interact with localization requirements under sectoral laws?
Yeah, so just it's a very obvious, expected, and a very good question. And I think first thing is that sectoral laws which have certain restrictions already. So we know that the RBI or the insurance regulations provide for strict data localization requirements. They will continue to remain. For any future requirements, what I understand based on reading of the rules, as well as combining it with some insights that Mr. Ashwini Vaishnav himself has given, it seems that the government is interested in maintaining a flexible structure. And for any future restrictions, there will be discussions with this special committee, which has been sort of, for which there's an avenue which is created in the rules currently, as well as the sector regulator, to see what sort of data and what category of personal data they would want those restrictions to apply on. So overall, on balance, I feel that the government is aware that there shouldn't be conflicts, and any future restrictions is something that is going to arise only after consultations, and potentially, sector regulators could also be part of this committee, which is supposed to be set up under rules to make sure that business is not disrupted, and different views are not taken under different applicable legislations.
Excellent. And I think now I'll start taking audience questions for all of us. And, so let me just start looking into the list. I think this one is for Smita. I think this question is from Shreya, and she asked that when talking about itemized list in the privacy notice, should this be a list of the personal data that is being processed along with a specific use case in a list? For example, name for X purpose, email for Y purpose, geolocation for both X and Z purpose, etc. Smita?
Yeah, that's a great question, and I guess quite relevant for the industry in terms of I won't call it panic, but see, the way I would like to put it across that I don't believe there's a reason to go that granular with the interlinking the purpose and the goods and services that you're providing. And secondly, what my understanding of this segment is, it's also extremely difficult to de-link usage of name, an email address, or a telephone number from what you're looking to do. Because what will happen is that most of these itemized personal data items are on a consolidated basis going to be utilized towards the services that or goods that are being provided. So I believe so long as you have listed out the data fields, you've said that okay, this is the broad purpose around that, and these are the goods and services which will be provided out of that process data. By using that, I believe you're home. I think the only category that may really merit this kind of a classification could be machine learning, research analytics, where the personal aspect of it may not be that relevant, and the metadata, which is basically more of a subset of your personal data, can be utilized towards that. So if you want to categorize it in that form, that it's possible that an aggregated form of that data is going to be utilized towards research and analytics without, of course, harping or harming the personal privacy rights, I think that's good enough. I don't believe we need that kind of granularity. Yeah.
No, Smita, I think a very interesting point you make, because I remember about a year back, I think 2023 December, when the minister was holding a consultation in relation to the draft rules, and it was told that it would be released soon. A gentleman from a telecom sector asked a question that, listen, I'm a telecom service provider. I give voice and I give data. Do I then need to have, say, separate line items that this data is for voice, this is for data, etc.? And the answer that came was like this: that, see, we don't think that that level of granularity could be required, because ordinary prudent person should be able to understand which portion goes for voice, data, etc., but nonetheless step into the shoes of the individual, okay, and try to understand that probably if I have to understand very clearly that this data of mine would be used for X purpose and this would be for Y purpose, that should be kind of called out. Another interesting question for you, Smita, which has come in: is it mandated for a data fiduciary to appoint consent manager?
No, not as of now in the rules or the act. In fact, that's the differentiating factor from the account aggregator framework. And personally, I would also view that as a shortcoming of a consent manager framework. Because if a fiduciary is not really required to integrate with the consent manager, then access to that data, running that process efficiently, that becomes questionable. Then we have consent manager, who are trying to get onboarded or get fiduciaries on board completely at a commercial level, with absolutely no incentive for a fiduciary to actually give out that data for another data fiduciary, right? So there's no requirement right now, but I do believe that at some point in time, if this ecosystem or if this support function has to flourish, I believe fiduciaries should be obliged to provide that data or integrate in some form. That's just my personal view.
The next question is from Niranjan. Very interesting question. Can you please explain the scope of the for the purposes of employment exception in under section 7? And question number 2: is there any distinction drawn between personal data and sensitive, highly sensitive personal data under the rules of the act? So I'll take the first questions first. Can you please explain the scope? So, when we were deliberating on this particular act, and we traveled across the country and attended almost every single consultation meet that occurred when Justice Sri Krishna consultation meetings were happening. What we realized is that probably for a country like India, consent is a very weak ground of processing. We cannot completely rely, and for various reasons, we need other grounds of processing. Okay. So one important discussion which happened, and I was part of that specific discussion, is that when we do internal employee investigation today, if you read the black letter of the law under the Information Technology Act and the sensitive personal data rules, it says de facto that you'll have to take consent from the individual, maybe of the employee who has kept sensitive personal data in the laptop of the organization. You'll have to take a sign off from that person, unless of course you have taken the consent beforehand. So in a bad day, it's almost an impossibility that that same employee will give you consent. So we needed another ground of processing, and therefore the discussion started that for purposes of employment should be another ground of processing personal data, right? Of course that evolved over time, and now you see a lot has been written. The first phrase which you have captured here in double quotes, Niranjan, for the purposes of employment, still remains open and kind of is a bit open to interpretation also. For example, can I also cover pre-employment related personal data checks or post-employment related aspects within that purview? Maybe it will evolve over time. But on a very practical basis, I would say that, see, India has largely been consent driven. Our regulator authority will also probably understand this better as we start sailing. Maybe as we become a more mature ecosystem, this will be better understood. So, right now, you may try to interpret this in a little more restrictive manner, depending on the kind of situation that you're looking at. As things evolve, probably this penumbra could increase, and there'll be judicial precedents to assist us, etc. Coming to the second question, which we have said, that is there a distinction between personal, sensitive, highly sensitive? The answer is no. You know that the DPDP Act tries to create a flat structure. There is no distinction between only personal data, sensitive personal data, critical personal data, etc. But two things I would still like to point out, that when you look at the provision in relation to data breach and the corresponding penalty, it's not like every breach that happens 250 crore rupees will have to be paid. Okay, it would be dependent, the penalty would be dependent on certain factors. Okay, it could be regarding repetitiveness of the breach, the kind of data that has gotten breached, etc. So that element, the type of data that has gotten breached, could kind of tie back to the fact that you should have protected a little more sensitive data more dearly as compared to personal data. So it's a practical suggestion. The law per se tries to create a uniform structure. One other thing which is now coming in, if you see the rule that was being talked about, which is in a way stating that the government might give some diktat against foreign regulatory surveillance of our data going outside. There it seems to drop a hint that certain kind of personal data could find a restriction as per that diktat. So let's see how that space evolves. I'm sure that there'll be a lot of recommendations and inputs being provided, especially this particular rule. But yeah, that's to answer your question, and I'll quickly now move on to the next question. How is significant data fiduciary defined? The Act does not provide any clarity around that. So, Anisha, maybe if you want to.
Yeah, so thanks for the question, Shubhatam. So significant data fiduciary has not been, it's been the factors that are going to be considered by the central government have been defined very clearly. And some of those I had touched upon when I was going through the slide. So it really depends on the volume and sensitivity of the data that you're dealing with, and the government is going to, and what is the impact on the rights of data principles, the sovereignty of the country, electoral outcomes. So those are the considerations which will be evaluated by the central government, and they will come up with a notification on the classes of data fiduciaries. Beyond that, we don't know anything. But again, had also mentioned that there is a call-in power for information. So data fiduciaries can be asked for their own information for the government to decide whether you should be categorized as a significant data fiduciary or not. So as of now, we just have some directional guidance from the mother legislation itself, along with the fact that in case you don't believe that you fall into a certain category, or if the government wants to classify another category, it's well within its powers, at least as per the draft rules, to summon that information from you and then probably decide that we designate you as a SDF, and now you have these additional obligations that you need to sort of discharge. So that's all we know for now. We'll just have to wait for the notification. Just how they have categorized some, we've gotten those retention periods that I had talked about: e-commerce, gaming platforms, social media intermediaries. Like, they have been identified and called out that these are the retention periods for them. It's possible that similar categories, and even for exemptions, if you see for for child processing, in processing of children's data, there are certain classes that have been called out. We think similarly fashioned classes will be notified by the central government based on the yardstick that has been very clearly indicated in the law itself.
Great. Thank you so much. And I think the next question is for Smita. The question is from Shreya, and she is asking, how do we take consent from existing customers?
So I think it's about legacy data. The requirement really is not to take that consent. It's only to send the privacy notice. So it's the law is giving you the window to give out a detailed privacy notice, along with the requirement and optionality to your customers that they do have the ability to withdraw consent should they choose to not have their data processed by you. So you don't really need to go that extra mile and take consent. Provide the privacy notice in the form that is provided in the rule, and that should be good enough. I would highlight the risk. It's possible that your customers come back and exercise that optionality of revoking consent, but frankly, that's the industry risk that everybody has to live with. Yeah.
Great. Thank you. Thank you, Smita. And the next question is from Shivangi. The question is for retention of data breach logs. Rule 6E states that such logs and personal data have to be retained for a period of 1 year. What do you see as an implication of this? Does personal data involved in the breach also have to be retained for 1 year? The answer is yes, Shivangi. I think that is probably the reading from all of us right now, that there would be this retention period for about a year in case that has been part of any kind of an incident. Like I mentioned already, this kind of goes beyond what the Computer Emergency Response Team of India, CERTIN, is already called out as ordinarily maintainable record of 180 days for all ICT system logs normally. So you'll have to extend that period to 1 year in case there has been an incident. I'll move on to the next question. Okay, this is from Apurva. Considering data fiduciaries have the responsibility to deploy notices in 22 regional languages, it becomes challenging to address the translation aspect when handling various request types. Addressing all requests across all languages becomes a Herculean task. Will there be any exemption? Can you please share your thoughts? So I think, Apurva, just to also give you a bit of a perspective, uh, this seems to be a favorite of the government right now. Okay, that all these notice, consent, this has to be put forth in English and any of the eight scheduled language of the constitution as may be preferred by the user, right? It is problematic, but let's also talk about what the market is doing right now. Thankfully, there are a lot of tools which have now come in which can almost instantaneously do the translation from English to those 22 languages. Are they perfect right now? The answer is no, but I think they will get perfected over time because good progress is being made. Also, practically, what are some of the organizations doing? What they're doing is they are at least trying to keep handy the English version and one or two other languages which are most relevant for the business where they are doing business. Okay. So that's what we are observing, and maybe this will shape up better with time. But yes, I don't see that this provision going out or any specific exception being brought in readily. Abhinav, this question is for you, and this is from Dipanshu, or maybe even Anisha, one of you can take this. What is the recommended approach for cross-border data transfer, such as conducting a TIA first and having DPAs with transfer clauses? Also, can you explain the role of data localization laws in India under the DPDPA? Maybe both of you can take this.
Anisha, would you like to take that up?
I can add in. Why don't you start?
Can I have the question again?
Yeah, I'll just tell you the question again. What is the recommended approach for cross-border data transfer, such as conducting a TIA first and having DPAs with transfer clauses? Also, can you explain the role of data localization laws in India under the DPDPA? I
So
think to
the
start off
DPDP
with,
Act,
sorry,
the
Abhinav,
D,
just one thought process there. I think whether we will go down specifically the TIA route from our side, from India side, will have to be still, I think, watched out
yeah.
for because that has not been clearly called out. Over to you, Abhinav.
So even for data localization, there is no prescription right now, correct? So uh, once the clarity comes in as to what kind of data sets, if some data set is considered as a critical data set which needs to be localized here, if those notifications come in, then only there can be an appropriate response and internal mechanism that can be built in for this, right?
Yeah. No, I think you're absolutely right, and we see a lot of flutter in the market already. Because you would remember that when we saw the mother legislation getting debated for so long, we started off with almost like hard data localization in one of the initial versions of the law, and then we saw some watering down to partial mirroring of the certain data and localization for certain others, and then we came down to this version which almost states like free transferability. When we finally had the DPDP Act rolled out, free transferability across jurisdictions minus those two catches. One is that the government will come out with a short negative list of jurisdictions. And the second thing is if there is a sectoral law which is more rigorous, and that will prevail over this general leeway. Simple example is RBI gives a diktat that payment systems related data should not leave the country. That will prevail. The RBI diktat will prevail over this general leeway. Now, are these provisions that are now coming in through the rules? I think there will be some refinements possibly because already the market is kind of getting prepared to give inputs on this and see that these are like aligned to the DPDPI probably. But anything additional, Anisha, please feel free to chime in.
I think the only additional point is that with these additional, rules and provisions which have come in the rules right now and additional restrictions, I think that also needs to be evaluated to be able to see what kind of impact assessments for transfer is needed. But I think at this stage, I agree with Abhinav and Shupratim that at this stage it may be a bit premature. Let's look at the final draft rules and then we'll decide. Hopefully the principles enshrined in the law will remain the same, and if at all there are any restrictions, they will be very limited in scope, and then I think we all will be in a better position to guide you as to how practical, what kind of practical steps are really required when you're looking at cross-border data transfer.
Great.
Although there has been
Anisha,
some early stakeholder comments favoring localization.
I think this question is interesting one from Apurva, and any one of you can pick up. How should organizations that have multiple legal entities in India should look at appointing a DPO? So, Anisha, maybe you can pick up.
So one is, I mean, technically a DPO with that sort of expression is required only for significant data fiduciaries. But I think if you are MNC, or if you have multiple offices and if you're dealing with large data, then obviously you need to have one point of contact who's acting as a person who's helping people exercise their rights, etc. So you should have a designated person who's technically qualified, and as is sort of savvy with the legal part as well as the technical part. So somebody who's techno legal, so they should ideally have at a group level. So what we are seeing increasingly is that large organizations, whether large domestic conglomerates or MNCs, have a team of 2 3 people at the group level who are coordinating and being a spock with different entities, who will also individually, those entities locally will also have those additional group entities will also have a spock or a champion for that entity who they are going to coordinate with. So it's going to be like a spider's web, where you have some people at the group level who are coordinating with their spocks in the relevant entities, who will then have privacy champions in each of their business verticals. So that just helps focus responsibility on certain individuals, and just helps with easier coordination, because we all know that as Indians, and culturally, we love to hoard a lot of data, and it's important that there's people who have focused responsibility on getting these things in place. So it's we've seen this work very well. It'll take some time, but that's what we have recommended to our clients, and I think in some of those cases this feedback has been appreciated and it's worked well. But it's horses for courses, so you have to see what works for your organization. This has worked as advice from Casio, so we are sharing that with you on a no fee basis.
Thank you so much, Anisha. I think next interesting question from Anurag, and he asks, how can we avoid consent fatigue based on the current legal framework? Anurag, like I was mentioning, when we traveled across the country during the Justice Sri Krishna consultation meets, we really understood that consent is a very maybe weak ground of processing, but we continue to keep our laws very heavy towards consent. But let me also tell you what some of the solutions were, which was put forth during the consultation meets. One of them was whether we should have a rating or ranking of organizations. Like, for example, this organization is A triple plus rated, just like you have in your financial instruments, and they're very trustworthy. You can freely and without any concern give your personal data. But all that got brushed aside, and finally, what stood the test of time, I would say, and finally found mention is the consent manager, which Smita has elaborated upon. I think this question, Abhinav, I think, would data fiduciaries need to conduct the verification as to whether a user is a child or adult for each user, or only where the user makes a self-declaration at the time of registering?
Okay, so again, the rules do not expressly state the government's intention on when the obligation would trigger on as to this verification. However, if we read the illustrations, all of the illustrations suggest that the intent is limited to cases where the child or the parent provides such information to the data fiduciary that the user is a minor or a person with disability. So I would say that the intent, as of now, seems to be that it will have to be on a self-declaration basis. Only then the obligation would get triggered.
Great. I think thank you so much. I think with that we will bring this Q&A session to a closure. We'll try and of course respond offline to the remaining folks whom we have not been able to respond here. But thank you so much for the overwhelming number of questions. We are thrilled that we could bring such an engaging session to all of you. Finally, I would like to thank each one of our speakers for sharing their views on the draft rules, drawing from your practical experiences and expertise in this domain. To our audience, I hope that you found this webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you a copy of today's presentation materials and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take the time to send in your feedback, comments, criticism, and even compliments. The form takes less than 1 minute to complete. And of course, please do not hesitate to contact us regarding any matter arising from this webinar. Our contact information is on this contact slide. And thank you for your attendance today. We look forward to seeing you again very soon. Thank you.
Thank you, everyone.
Thank you, everyone. Bye.